good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting very patiently. And while we're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's talk entitled What Can Go Wrong in a Sales and Purchase Agreement for Property. My name is Jazin Wong and I'll be your moderator for today's session. Before we start today's talk, let me first introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by our Dato' Ma Wing Kwai. Our able team today comprises of 22 lawyers and a support team of 19. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, also known as SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment industrial relations team, as well as a department focused on servicing the needs of individuals and families. Our practice groups, as you can see from the slide, indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for our clients, potential clients, and in-house counsel. This is our 19th talk in 2021 for our online talk series, which has been attended by some 3,000 attendees. Today, we're expecting 226 people who have registered. Please visit our website at mawingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Detail will be given at the end of our talk. Today, we have two speakers, one Ms. Sarah Kambali and one Mr. Marcus Leong. Ms. Sarah will be speaking first, followed by Mr. Marcus. We will then conclude today's session by addressing the questions raised. To all the participants, kindly post your questions in the Q&A box below. Allow me to introduce our speakers for today. Sarah is a partner in our firm and who does real estate practice group and Sharia estate planning. She has a Bachelor's of Law from the International Islamic University of Malaysia and postgraduate diploma in Sharia law and practice from UiTM. She was admitted to the Malaysian Bar in 2007. She is mostly involved in real estate transactions and Sharia estate planning. Real estate transactions include drafting sales and purchase agreement, transfer of property during lifetime and death, drafting tenancy agreements, reassignment or discharge of property. Sharia estate planning including advising on drafting of wasiat, preparation and execution of hibah, understanding farid. And she's also a member of the Selangor Bar Conveyancing Practice Committee. Our second speaker for today, Marcus. He is an associate in our real estate department, wills and trust and probate team. He has a first-class honours in Bachelor of Laws from the University of the West of England. He was called to the Bar of Malaya in 2018 and completed his Master of Commercial Law in University of Malaya. He does conveyancing matters, drafting and preparing sales and purchase agreements, loan documentation, transfer of properties, probate matters, drafting and preparing wills. He also does advising on grant of probate and letters of administration applications. Our speakers will target to complete their presentation by 3:45 p.m. today, and then they will address the question posted in the Q&A. Today's talk points are as follows. The problem with both parties using one lawyer, avoid being the victim of fraud, consequence of delays, and communication and the client experience. Ms. Sarah will be covering point 1 and 2, and Marcus will be taking over to discuss point 3 and 4. I will now hand over the virtual floor over to Sarah. Sarah, over to you.
Thank you very much, Jaslyn. Good afternoon and welcome, everybody. Thank you for spending your time with us for today's talk on what can go wrong for a sale and purchase transaction of property. I see there's many of the participants here, close to 140. Thank you for coming. The first talk point that I will be presenting is the problem with both parties having one lawyer. I'm pretty sure that many of you who signed up for this are eager to know what's the problem of having one lawyer for a sale and purchase transaction. Let me also ask you, in a litigation case, you won't have one lawyer representing both plaintiff and defendant. Same comes for sale and purchase transaction. Sure, we're not dealing in court, but we are your lawyers serving and representing you in the transaction. Let me give you the preference that I know. Many of us have a preference of having only one lawyer. Why the preference of one lawyer? Many surveys would come across with this first reason: costs. They want to save costs. This would be the first and foremost reason of why you want to choose one lawyer. One lawyer in a sale and purchase agreement transaction means the purchaser, the vendor, and the financier lawyer all in the same, and cost is reduced. Time. The myth of time being much shorter when you use one lawyer. Next is convenience, and it's a standard procedure. These two has always been gone hand to hand. It's easier to take one lawyer, convenient to have one lawyer. It's a standard agreement. We don't need two lawyers. Followed of a suggestion made by a third party or an agent. It could be a real property agent. It could be a bank agent. I'm not saying that this is a terrible idea, but it is not something that you should do. Because if you have following only one lawyer and not an individual lawyer representation, there will be consequence. Next is some even do not know that they have the right to appoint their own lawyer. The purchaser or even any party might just say, it's okay, you can join my lawyer. Or even the lawyer themselves would say, it's okay, let's join one lawyer. Reality of one lawyer practice. Costs. There is a possibility that you want to cut costs, but who is exactly cutting costs? The purchaser will still be paying full fees, whereas the seller, which is the vendor, will probably not be paying fees for preparing or vetting the agreement. But there's a cost to the cost, which means you don't pay your fees for someone to advise you. You wouldn't know what goes on. You can ask that lawyer because you say one lawyer, but it doesn't work that way. All right. So later on, when there's problems in the middle of it, the reality of one lawyer is that vendor, and usually vendor is the one unrepresented, because in one lawyer practice, purchaser will always be represented because the rule of thumb is that the purchaser must be represented and the vendor is not represented. So when the vendor is not represented, in the middle of it, if there's certain things that happen, the vendor might just hire a lawyer, which will add on costs and time. Another issue is towards the end, it's almost ending already. And for some reason, things just go bad. The purchaser's lawyer will always take care of the purchaser's rights and interests. So what happens to the vendor lawyer? You possibly engage a litigation lawyer for dispute arising. Time. Everyone thinks that time is shorter with taking one lawyer. Communication time, possibly. But in fact, in actual fact, time is never shorter. You still have to go to 3 months of a minimum time to finish up, complete a transaction. Minimum is three months, and this would be informed by my colleague Marcus later. So it doesn't matter if you have one lawyer or 2 lawyers or 3 lawyers. It's the same time to complete the transaction. And possibly the third reason is this. Oh, hold on. Before that, let me just show you what is the cost. So if you look at the cost, right? This is the scale fee cost of a lawyer when you hire a lawyer. So each of party, whether it's SPA, sale purchase agreement, or a loan, whether you're a purchaser or a vendor or a borrower, you will have to pay this cost. The first one is if it's SPA, let's say the property is 500,000. So your cost of lawyer fees is 1%. And this part here, you see the first column is actually the total value or the purchase price of the property. So the second percentage is our fees. As you can see, it's 1%, 0.8, 0.7, 0.6, 0.5, and the total here is 7.5 million. So if it's more than 7.5 million, it's negotiable. So this is the cost. And this cost is a scale fee that's already been set in the solicitor's remuneration order. Okay, Next, possibly there's this reason of why we are taking reality of one lawyer practice. Convenience and standard. Possibly because you want to be in a convenient state where you only have to deal with one lawyer. But in real actual fact, think about it. Is it convenient for you or is it convenient for the other party? There is no difference in time taken to complete a transaction. So there's not really a convenient issue here. And every sub-sale agreement, so a sub-sale agreement here means sale and purchase agreement that is done after the first agreement, which is bought by developer. So anyone who bought a property from the developer, that's the first agreement. Anything after that is a sub-sale purchase, sub-sale agreement. And sub-sale agreements, there's no standard to it. It's an agreement that has terms and conditions. It might be similar from one case to another, but there is no standard agreement. Yeah. Follow suggestions of third party or an agent. Law firm will be representing only the purchaser and the vendor will be assisted by the lawyer. Last but not least, the reality of one lawyer practice is that all parties, or rather the party that is, we call it piggybacking or just following or for mere convenience, possibly does not know their rights. Their rights to be advised of the clauses in SPA, in the sale purchase agreement. If you piggyback or if you follow one lawyer, you have a problem of not understanding the clauses. You would probably have to agree because usually when the draft is given to you, you would see and you don't know, you're not highlighted what is your right. Okay. You are not given the progress update. For example, if there is an application for a consent or a redemption from the bank, there's no progress update from the lawyer because the lawyer is representing the purchaser. It's not representing you. So the progress update timeline of consent for the redemption or any of those matters is not given to you. You can call them, you can try. How many of you have tried? You try to call the lawyer, but the lawyer doesn't want to answer. Usually that happens if you have a one lawyer practice. If it's more than, if you are actually represented, you can complain if this happens. But if it's one lawyer practice, if you go and complain it to someone and you'll be asked whether this is your lawyer or is it you follow a lawyer, means you're not really represented. Then with one lawyer practice, you won't be able to see whether your real property gain tax is submitted or advised properly. Right now in Malaysia, even if you have held the property more than 5 years, you would still need to submit the real property gain tax. And lastly, if you do not have your own lawyer, you cannot do a due diligence. That's your right. You have the right for a due diligence, for a check on the transaction to avoid any fraudulent activity or AMLA. These may be the scenarios of one lawyer that are not ideal. I do see some people who are picking up their hands. Can you hear me? Okay. Because I'm seeing some people who's raising their hands. I'm not sure why. Thank you. I see the chats. Thank you very much, everyone. All right, I will continue. Scenarios of one lawyer that is not ideal. Property that is still in the name of the developer or proprietor means that it has not been perfected we call it perfected, means it has not been changed to your name. If you have this kind of property, it's not ideal for you to have only one lawyer. Properties that is in the name of the administrator or the executor, many issues can come up. You cannot have only one lawyer. Your rights will not, the beneficiaries' rights will not be taken care of. Property that has restriction in interest. So what is restriction in interest? These are properties that require you to apply consent. And properties where the purchaser is not a Malaysian. In other words, a foreigner who wants to buy the property. Why is this not ideal? Because when the purchaser is not a Malaysian, they have to have an application for foreign consent. And that would need their own representation. We do not recommend a one lawyer situation. And lastly, properties that are subjected to real property gain tax. Why? Because more often than not, the lawyers would really need to give advice on what are the documents that are needed to be provided for any transaction of real property gain tax, whether or not the real property gain tax is exempted due to certain gazettes, or it's not exempted. Because in Malaysia, after 5 years, you are still subjected to real property gain tax, unless you fall into the exemptions. Legality of one lawyer practice. Under the Bar Council ruling, Rule 6, a lawyer is prohibited from representing both purchaser and vendor in the same transaction. Why is this so? It's because mainly we cannot have two masters. We can only have one. And it conflicts the interests of each party. As you know, vendor, seller, what is their interest? Their interest is to get the property sold, monies received. Yeah. And this interest is different from a purchaser. A purchaser is when the properties are being bought by them. And they want to make sure the property title, the property assignment, or any kind of those kind of property details are transferred to them when they give out the money. Do you see how different these two roles are? It's a conflict of interest for you to be representing one lawyer. As for the financier lawyer, their interest is to make sure that the property is actually charged or assigned to them. Assigned here meaning that if the property is under master title, then it should be assigned to the bank if they're taking up loan. Okay, this is one of the case study that I have. We'll just go through it quickly. Ng Siu Lian versus John Lee Sui Vui and another. So the defendants, the John Lee Sui Vui and another, are defendant one is the lawyer himself, and defendant two is the law firm. Ng Siu Lian is actually the plaintiff who is the purchaser, claiming against the first and second defendant for a sum of money of 600,000 that she has paid for a piece of land. A little bit of other background. The land has its sekatan kepentingan, it has restriction in interest. There's a lot of things that the lawyer has to make sure that this can be transferred. So what did happen? She was also asked by the first and second defendant to sign a letter of disclaimer. This was prepared by them to absolve liability. Usually purchasers do not sign any disclaimer letter, but this law firm did. What happens when that happened? The purchaser, the plaintiff here, had bring up an action because she was deceived into buying the property. The property was never transferred to her. In High Court, it was dismissed because they said the letter of disclaimer works, but here in the appeal, no. What is the crux of this case? Is not just that. The crux of this case is that because the plaintiff doesn't know that the first and second defendant is also representing another company, as the name here mentions, NCT Forwarding and Shipping in Sabah, Sdn Bhd. who is interested in the 5 lands, which includes the plaintiff's land. So they were just trying to scuttle the deal, and they are representing NCT as well. So you can't really represent 2. And in this case, it's not even purchaser vendor. So this is a clear cut of conflict of interest. The judge mentioned here that being the solicitor of the plaintiff, you're representing the plaintiff in this land transaction, first and second defendant owe a duty, a fiduciary duty, a duty to take care, not to injure her by failing to do what was undertaken to do, which is to represent her and effect the transfer of the title. Therefore, the law firm and the lawyer cannot rely on the letter of disclaimer. I hope that's clear for now. I will jump into the second one, which is avoid being the victim of fraud. I see some question and answer. I will reply that later. Any question and answer, please put it in the Q&A, not in the chat, in case we missed it out. We will have a Q&A session at the end of the slides. I mean, at the end of the session. Moving along, avoid being the victim of fraud. In order for you to understand and make sure that you know what is fraud, you have to go through all this information of definition, so you can avoid being the victim. Fraud is not particularly defined in the real estate laws. They don't have fraud is what in National Land Code. It just defines the situation in the National Land Code. I shall share with you in a bit. But mostly fraud is when you have an intention to cause harm or hardship to another person. In the online definition, fraud is a deliberation misrepresentation of facts for the purpose of depriving someone of a valuable possession. Fraudulent activities includes theft, extortion, corruption, money laundering, or bribery. Common scenarios of fraud. Identification fraud. We have many cases where the vendor, supposedly the vendor, but was not the vendor. In other words, they say they can sell the property, they gave the IC, but the IC was fraudulently changed. It was forged and fraudulently changed. Ownership, altering documents. This could happen with the title itself. So that's why it's very important for you to have a lawyer to vet through the agreement and the documents that is given. Next is misrepresentation of information. Through a lawyer, or rather through having your represented solicitor, you would actually get a sift, or rather ditapis lah, the information that you need so that it doesn't become misrepresented. In National Land Code, it mentions in section 422, what are the fraudulent acts? One is making false statements, whether it's orally or in writing, during a dealing or other transaction affecting the land. You know, when it's in here means if anyone is caught doing it, you are going to go through a penalty, which I will share as well. You do a fraudulent act if there is an investigation under the act and you fraudulently say something, making false statement about it. Give false evidence during an inquiry. Land Office, at times, they do have an inquiry. And when you do go for the inquiry, you give a false statements, and that is a fraudulent act. Other fraudulent acts are procuring or registration and making of and cancelling of any of the document of instrument. This means, for example, your title, your original title, you never lost it. Someone fraudulently made a new one from the Land Office. That's a fraudulent act. So this is a fraudulent act. Suppress or conceal material facts. You do not tell the registrar the proper information. That is also a fraudulent act. Under 423, fraudulent act says that people who alters, adds, erase, deface, destroy any document of title or other instrument relating to land. This can be any kind of forgery as well that you change in the Borang 14A, the transfer form, and all the same. Penalty for fraud. Under Section 422, the penalty is 500,000 or 5 years imprisonment or both. And under 423, if you're caught and you are mentioned to be guilty, it will be 500,000 or 7 years imprisonment or both. Recently, this is a recent amendments. Previously, it was 5,000 ringgit and 3 years or 3 years imprisonment or both. Okay, let's go on to the case study for fraud. This case, Lim Ying Chun against Joseph Ling and others, is a case where there were 3 titles that were alleged to have been missing at a coffee shop in Nanam, Sabah. The application was certified copies made by the first defendant. So Joseph Ling and others is actually a law firm. So they prepared the SD and whatnot to actually get the missing titles. There was also a power of attorney and statutory declaration which was prepared by the first defendant with the plaintiff's signature being forged. So who is this plaintiff? This plaintiff is actually someone who stays in Taiwan, because he's in Taiwan and he's Taiwanese national. He was keeping all 3 titles with him. Plaintiff has never visited Sabah during that time because of his illness, and the signatures of the plaintiff or any document was actually forged. The judge has said that this is a standard of proof is now low and at the balance of probabilities, and because it is shown that the originals are with the plaintiff, therefore this is a fraud case. It shows, so all the transactions that happened with these 3 titles were reverted back, and it was no longer sold off because the issue it was sold off. How to curb forgery and fraud? One is that you have to have a lawyer, because every lawyer will have this thing called practicing certificate, which requires a PII, professional indemnity insurance. If ever you are going through a fraud or anything like that, you will be covered because you have your own lawyer to get the, if it's a case where you need to get damages, so that will cover it. With such payment of PII, they will cover against negligence and unable to perform. So lastly, if you want to curb forgery and fraud, you must hire a lawyer on individual terms. That's one thing you have to do. And that lawyer will have to exercise care and diligence. How do you hire a lawyer? Not by looking at how much they cost. Sorry, there was a phone call. Not at how much the lawyer costs or how much discount the lawyer can give. You have to look into the integrity of the lawyer themselves. Because if the lawyer doesn't exercise care and diligence, they don't collect the documentation properly, and they don't verify and identify the identities, and they don't do a search online, physical or online. This is searches like bankruptcy search, all those kind of searches. If they don't do that, and they don't communicate with you, which is a no-no, and they don't report to the authorities there's a wrongdoing, the lawyers are not a reliable lawyer. You have to find a lawyer that actually has all these reliable sources. So in order to reduce fraud, we must think of 4 steps of A, B, C, and D. A is that we must be aware of your lawyer that you are hiring or you're representing, not because of how much they cost. Be alert, stay up to date. This is always, you can find news on The Edge. They always cover things on fraud or property matters. Continue to educate. This is more towards attend things like this a seminar and educate others as well to make sure that you don't go through a fraud. And exercise diligence, this will be on your lawyers. With that, I'm done with my presentation. I will pass you now to Marcus Leong. Marcus, take it away.
Thank you very much, Sarah. I'll share my screen now. All right. Afternoon, everyone. My name is Marcus, and I'll be covering point 3 and point 4 today. Point 3 will be consequences of delay in a sale and purchase agreement. Right. So in sale and purchase agreements, there is actually no fixed timeline for the completion, and it varies according to the parties. Parties may agree to the timeline they want, but time shall always be of essence in sale and purchase agreements. What is time shall always be of essence? It means that the deadline is a condition of the contract, and if time stipulations are not met, the party not in breach will be entitled to terminate the contract. So, for example, if the vendor cannot meet the timeline, then the purchaser who is not in breach will be entitled to terminate the contract. Right, so for sale and purchase agreements, the most common timeline for completion is 3 months from the date of the agreement, with an extension of 1 month in the event of any delays of the payment of balance purchase price due to unforeseen circumstances. But then there's a condition, is that during this extension of 1 month, the common practice is that there will be a late interest of 8% per annum, depending on the terms of the agreement. And once again, this is just a common practice. It could be higher or lower. Okay, so the delay that we mentioned just now is usually from the buyer's side to pay the balance purchase price. But what happens if the vendor delays the completion? The sale and purchase agreement usually does not penalize the vendor in delaying the completion. But then what it does is it extends the completion date for the purchaser to complete the transaction. In the event the vendor delays the completion, what we suggest is that the purchaser could go with the vendor and ask for early VP pending the completion of the transaction. Okay, after covering the delay in S&Ps, we are now in delay in stamping. So instruments executed in Malaysia, which are chargeable with duty, for example, the memorandum of transfer, must be stamped within 30 days from the date of execution. And if it is executed outside of Malaysia, it must be stamped within 30 days after they've been first received in Malaysia. So what happens if you cannot make it within 30 days? Penalty, of course. Within 3 months from the expiry of 30 days, there's a penalty of 25 ringgit or 5% of the deficient duty, whichever is higher. And if it is within 6 months, but more than 3 months from the expiry of 30 days, the penalty is 50 ringgit or 10% of the deficient duty, whichever is higher. And lastly, if it is more than 6 months from the expiry, it is Rm 100 ringgit or 20% of the deficient duty, whichever is higher. All right, so besides stamping, we also have to submit RPGT forms or retention sum to LHDN. So for each disposal, both the vendor and the purchaser are required to submit RPGT return, respectively, within 60 days from the date of disposal. The date of disposal here means the date of the sale and purchase agreement. And the purchaser's solicitors is required to withhold 3% of the purchase price as retention sum and remit to the Inland Revenue Board, this is LHDN in English, within 60 days from the date of disposal. Right, so what happens if you are late? And of course, there will be penalty as well. In the event that there's a delay in submitting RPGT forms or 3% retention sum, there is a penalty under subsection 29(3) of the RPGT Act, and this penalty can be charged up to 3 times the amount of tax charged, and this could be quite heavy. Right? Now we are in the 4th point, which is last for today, is communication and the client experience. First of all, the relationship between a solicitor and his client is one of a fiduciary relationship. What is a fiduciary relationship? The word fiduciary actually means trust or confidence. So in other words, in a fiduciary relationship, the client places his trust in the solicitor to advise and assist him in his legal matter. And a solicitor is bound to give advice to the client at a fee according to the solicitor remuneration order, which was shown by Sarah just now, which is the scale fees that we have to follow. And upon commencement of the solicitor's appointment, the solicitor shall always make full and frank disclosures to his client with regards of the client's interests in the sale and purchase transaction. And the solicitor shall not exclude the client from full knowledge or disclosure. In other words, the solicitor should not be hiding anything from his client regarding the client's matter. Besides, the solicitor shall also ensure there is an effective and prompt communication between the client and himself. As a matter of common practice, the solicitor should update his client regularly on the matter involved. For example, it is better to contact your clients compared to them asking you for an update. In the event that there's any urgent issue that requires the client's attention or clarification, such issue shall be dealt with immediately. Okay, in a fiduciary relationship, the solicitor shall always exercise reasonable care and skill in providing the client his advice. One solicitor shall take the necessary steps in respect of the matter which is demanded of a competent and reasonably experienced solicitor. So there's a reasonable standard to be met. And solicitor shall also refrain from taking advantage of the fiduciary relationship for his personal benefit or gain. For a sale and purchase transaction, client can hire either a conveyancer or a solicitor. By hiring a solicitor, the solicitor could provide the most suitable legal advice and ensure that one is protected under the law. A solicitor will also at all times act for the best interests of their client. So here's the difference between a conveyancer and a solicitor. For a conveyancer, usually they only work in conveyancing and do not have any other qualifications. Whereas for solicitor, they focus and specialize in real estate and they are well versed with the law. Other than that, conveyancer always or usually works in real estate agencies or property advisor offices, whereas solicitors, they are all in law firms. Lastly, a conveyancer may not be as well versed in the law compared to a solicitor, and compared to a conveyancer, solicitor should have better knowledge of the law. All right, that is my very short presentation for today. And now we are taking questions. So over to you, Jaslyn, to...
Thank you, Marcus and Sarah, for sharing with us. I will now be answering some of the questions in the Q&A box. The first question is by, is current practice for loan agreement lawyer appointed by a bank and the fee paid by purchaser? Then who is this lawyer representing, the purchaser or the bank? Marcus, do you want to take this question?
All right. The short answer is that this lawyer is actually representing the bank because we are preparing the loan documents and loan agreements for the bank and the borrower to sign. Thank you very much, Jaslyn. And I also think the same person answered it himself. Yeah. All right, thank you.
All right, the second question is, what are the extra steps to do or check if the name is in administration or executor? Sarah, do you want to take this question?
Sure. Thank you very much, Jaslyn. Thank you to the attendee who's asking this question. What are the extra steps do you need to check if name is in the administrator or executor's name? First and foremost, we have to make sure the documentations are correctly done. Means if it's administrator, there must be a letters of administration. If it's an executor, there must be a grant of probate. Those are the two documents that will name who is the administrator or the executor respectively. And therefore, if the documentation, in other words, the title itself doesn't mention these two persons, it's fine as long as you have this letter of administration and grant of probate. Back to you, Jaslyn.
Thanks, Sarah. The third question from the earlier question also. So he says that, yes, the lawyer represents the bank where they follow and set terms set by the bank. He's asking if that is correct. Marcus, you want to answer this one?
Okay, thanks, Jaslyn. This is correct. Yes, the lawyer actually represents the bank. Thank you very much.
And the next question, what is the max compensable amount under PII? Sarah, do you want to answer?
Thank you so much, Jaslyn. The max compensable amount under PII will depend on it's like insurance because PII is insurance. It will depend on the mandatory amount that the firm takes up. So I can't really tell you what is the maximum because it depends on how much is the amount that particular firm takes up. Thanks.
Thanks, Sarah. The next question is, since the interest rates are so low these days, have you seen interest rates for delay reduced to, say, 5%? Marcus, do you want to answer this one?
Okay, Jaslyn. For this interest rate, I assume is the late penalty interest. So for sale and purchase agreements, actually, there is no fixed term. As long as it is agreed by both parties, it could be any percentage for the interest rate. Do you have anything to add, Sarah?
Thanks, Marcus. That is correct. But usually for everyone's standard procedure, they always put 8%. But you are right, Marcus. You can put in 5%. If both parties agreeable to 5%, then you can tell the lawyers, look, we both agreed on 5%. So we will draft the agreement based on 5%.
Thank you so much, Sarah.
Thank you, Marcus. Thank you, Marcus and Sarah. The next question is, are there ways we can refer pertaining to lawyers' performance, especially when we are new to them?
I'll take that, Jaslyn. Well, for our firm, I don't know about other firms, but for our firm, we have a feedback form. Every time we finish up one file, whether it's litigation or conveyancing, we hand out a closing letter together with a feedback form. It's a little bit tedious on our end, true, but it helps us to improve. So if you feel that we need to communicate more or we lack in certain things or you like us for certain things that we do, we will take note of it and we will apply it to other files as well, other transactions that we go through. But other firms, we are not sure. Thank you.
Thanks, Sarah. The next question is, due to the current situation of COVID-19, delays on part of the government officers like the LHD and land officers, what is your opinion if the completion date were made longer than the common completion date of 3+1? Marcus, do you want to answer this?
Yes, Jaslyn. So one suggestion to this problem that might arise is that now we put an extra clause in the SMP saying that whenever there is a lockdown closure of office, the completion period will be paused and it will not continue to run until all these offices are back to operation. This is a suggestion from us, and I think it's really useful to have that clause in the SMP. Yeah. Thanks, Jaslyn. That will be all.
Thanks, Marcus. The next question is in regards to sub-sale. What is the minimum and maximum interest rate that can be imposed for extension of completion date? Sarah, would you like to answer this one?
For this, we don't really have a minimum or maximum. The usual procedure is 8%. Some lawyers out there, they even decide that there shouldn't be any interest rate in the first place. So there is a movement for that as well. So it really depends on how the parties respond to it. So if the lawyers say you must die must 8%, it's actually not, yes, die 8%. If both parties say 1%, 2%, 0.5%, it's fine. It really depends on the parties. Back to you, Jaslyn.
Thanks, Sarah. The next question. In the event that the actual RP duty is less than 3% of the retention sum that was remitted to LHDN, is there a fixed time frame for LHDN to refund the balance? Marcus, would you like to take this one?
Yes, Jaslyn. From my own experience, it's quite hard to estimate when they can refund the balance. It also requires a lot of follow-ups and calling them, writing to them. So from my own experience, I don't think there's a fixed time frame for them to refund. Unless you keep chasing them, then it could be faster. Yeah. Sarah, any thoughts on this?
I would like to say it's supposed to be 30 days because usually that's how long it would be on a refund basis. But let's just say after the 30 days, they still have not refunded, then you need to give them a call. They might have overlooked. And the person who should call is not the lawyer, by the way, it's the taxpayer themselves. My experience, I was years back. That's why I never call for any client anymore. My experience is that the LHDN officers will tell me that this is PNC and lawyers are not privy to this. So you're not supposed to follow up. That's what I was actually being schooled by the LHDN officers. So as much as I want to help, it's not possible. Maybe you get other officers they might give, but the rule of thumb is that lawyers are not supposed to follow up. The following up should be the taxpayers themselves because the money will go in your account, the account that you register with the tax department for your income tax and things like that. The money will go there.
Thanks a lot.
Thanks, Sarah. Thanks, Marcus. Next question is, in the event there is a delay of VP for a new property, how do we claim for LED? Does the purchaser need to sue or it will be automatically engaged by the SPA lawyer? Sarah, would you like to take this one?
Sure. You claim the LED through lawyers, it's better because the lawyers, but you have to find for a lawyer who's not a panel of the developer lah. So you claim for an LED, the lawyers will write in the letter of demand and then they can follow up with a suit. Of course, it's a little bit more pricey if it goes through lawyer, but usually it moves better when you do engage in a lawyer. Back to you, Jaslyn.
Thanks, Sarah. A very quick question for the next one. Does a conveyancer have to have a law degree? Marcus, you want to answer this one?
Okay. Possible, I would say. Possible, they do have a law degree. But then for solicitors, we have to go through the CLP first, if it's done locally, or the bar exams in overseas. before we can start pupillage and then to get called in the bar to become a solicitor. So a conveyancer, I don't think they have those requirements. But having a law degree is possible. Yeah. Thanks, Jaslyn.
The next question is, what happens if the developer strong arms the purchaser in terms of LED payouts? Is there any way to work around it? Sarah, would you like to answer this one?
I would seriously say get a lawyer. Because usually when you hire a lawyer, it's a much stronger case for you to get the developer to pay up. Thank you.
Thanks, Sarah. The next question is, if MOT executed overseas by purchaser with embassy dated the MOT, but the developer is yet to execute for more than 30 days now, will the MOT be subject to penalty upon adjudication? Marcus, do you want to take this one?
Yes, Jaslyn. If it is executed overseas and they have dated it, sometimes we will try to ask our clients in overseas not to date the MOT in case this happens. But if it really happens, then we will normally ask for extension of time to avoid the penalty. Sarah, what do you think about this one?
It will be subject to penalty upon adjudication because, as you know, the date is there already. Our practice, we would probably ask the developer to sign first if this is the situation before sending it over to the purchaser, because this is either a perfection or a direct transfer. So you need to get the developer to sign first if the purchaser is overseas. We would suggest to do that to avoid penalty.
Thanks, Sarah. Jaslyn, back to you.
Thanks, Sarah and Marcus. The next question is, what if the loan lawyer's delay causes financial loss to the purchaser? Is it that the lawyer will not be responsible since he represents the bank, or should there be a duty of care by the lawyer to ensure that the interest of the purchaser is not affected? Sarah, would you like to take this one?
Sure, thank you very much. Here it says that what if the loan lawyer's delay causes financial loss to the purchaser? I'm assuming the financial loss is that there's a penalty going about, yeah? So if it is the loan lawyer themselves, the issue of penalty should be paid by the lawyer themselves. But we have to look into what is actually the cause of delay. So we have to do a intricate CSI kind of thing in the file before we can actually say it's the loan lawyer who needs to be paying for this delay. Yeah. So back to you, Jaslyn.
Thanks, Sarah. There is one question that's asking to explain what Form 14 is. Marcus, would you like to answer this question?
Thank you, Jaslyn. Yes, I assume this is the Form 14A, which is the Memorandum of Transfer. So in order to transfer ownership of a land or property, you have to, and if there's a title to that land or property, you have to execute this Form 14A to transfer the ownership. So both parties, the transferor and the transferee, they have to sign this Form 14A to transfer the ownership. Thanks, Jaslyn.
Thanks, Marcus. Looks like we are running out of time, so we will just be taking another 2-3 more questions. The next question is, for subsale purchasers, if a subsale purchaser is a Singaporean and was signed and witnessed by a lawyer through video call, is this subsale transaction valid? Sarah, would you like to answer this one?
Simple answer, no, it's not valid because in Malaysia, we don't do the whole transaction of through video witnessing thing. So no, this is not valid.
Thanks, Sarah. The next question is the certificate of fitness of the property a usual thing to do from the vendor, a usual thing to ask from the vendor? Marcus, would you like to answer this one?
Thank you, Jaslyn. Yes, I would think it is a usual thing to ask from the vendor. However, if you are a solicitor representing the vendor and the vendor doesn't have this, so it's better for you to not include it in the sale and purchase agreement. So both parties will have to come to an agreement to remove this from one of the conditions, that this is a must-have document to be provided by the vendor. Because most of the time, vendors cannot find their certificate of fitness, and there's no choice but to remove it from the sale and purchase agreement to say that this is not a must-have document provided by the vendor. Thank you, Jaslyn.
Thank you, Marcus. I will just be answering one last question for now. What can a purchaser do when the SPA has been delayed due to the land office by reason of this pandemic? Sarah, would you like to answer this one?
Well, that really depends on what is in your sale and purchase agreement. If your sale and purchase agreement does not mention anything, then it's a bit difficult for you to proceed with any kind of negotiation. And it depends on whether the vendor is agreeable to any kind of negotiation for time. If not, the purchaser has to pay for its penalty due to the land office delays. But usual, sale and purchase agreements, there will be, whether it's pandemic or not, if there is a proof that the delay is made by the developer, by the land office, even without the clause about the pandemic, if there is proof that this is a delay done by them, and it's nothing a consequent delay of the purchaser or the lawyers themselves, it's not an additional of that, then time will be extended. That's the situation. But other than that, there's not much the purchaser can do unless the sale and purchase agreement states it. That's why you need to have your own individual lawyers for you to be able to be advised whether you're a purchaser or a vendor of your rights, whether can extend time or how delays are dealt with. Back to you.
Thank you, Sarah. Thank you, Sarah and Marcus, for sharing with us. We're so sorry, everyone, that we're not able to answer all the questions, but don't forget that you can contact us for a 30-minute free consultation or email us to make an appointment. Before we conclude, I have a few announcements that I'd like to make. First, please join us again for our upcoming talk on the 13th of October, titled Understanding Shareholder Agreements, which will be given by our Cassandra and Mr. Tommy. Secondly, please fill in our feedback form and tell us what you thought about our talk. The link to the form will be posted in the chat box. Thirdly, follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. You can look at the slides to see the usernames. And fourthly, if you would like to speak to our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box. Thank you to our guests for joining us for today. We hope you found this session very informative and useful. And we'll see you in our next talk. Thank you.
Thank you very much, everyone.
Thank you, everybody. Take care. Thank you.